Hi, welcome to I think it's week 10, and so we're talking about copyright this week, which is a really important area of law because it's one that you can easily break, and that students quite frequently do break this law, and it can actually end up being costly if you're not careful. So uh, don't imagine this is something which is just theoretical that applies to other people. This applies to you, and the material you use in your stories that you'll be publishing while you're at university and beyond is likely to be protected by copyright. And so basically it belongs to somebody. And if you take it without their permission or without paying for it, then you're basically stealing. So you need to be really careful because there are increasing number of people who will challenge you over that and basically ask you to pay for it after you've taken something, and it can be quite costly. So let's have a look at this issue of copyright. Before we do, another reminder about the exam. So it's not, still got a little bit of time, but it's getting closer. 10 o'clock in the morning on Tuesday, May the 18th. A few weeks away. It's an online exam, so you don't have to be anywhere particular, but you do need to make sure you've got a good internet connection and you are sitting somewhere where you're not going to be disturbed. It's an open book exam, so you'll be able to refer to things like McNae's. It lasts for 90 minutes. Even though it's an open book exam, if you try and do this without doing any revision or work beforehand, you will come unstuck. I've seen it too many times now where people think, oh well, okay, I can just look the answers up on the day. You've got 90 minutes to answer the questions. If you try and look up each answer, it will take too long and you will not be able to successfully complete this exam. And you do need to successfully complete this exam because this is one of the rare assessments you do where you actually have to pass this individual specific assessment in order to pass the module, and that's because of the BJTC requirements. The Broadcast Journalism Training Council, who accredit the course, they insist that you pass a law exam. And that's perfectly reasonable because if you don't have a good grasp of the law, then you are potentially a dangerous journalist and can get yourself and other people into a lot of trouble very quickly. When you're answering exam questions, or really the way that you should be learning all of this for law, you need to be very organised and structured, and I would recommend that you work out what's the legislation that applies to each area, how do you define that area of law, and then what defences apply. If you use that as a structure for your answers, then you should be okay. So what are we going to do today? So I thought I would divide it up into three hopefully fairly short videos. And so in the first one, I'm going to be looking at the basic definitions of copyright and maybe have a quick spin through a few case studies. Second one, we'll be looking at who actually owns copyright, how do you work that out, and how long it lasts for. And in the third video, we're going to look at some of the defences that are available to you. So basically, copyright does include you. So if you are doing a story and you think, oh, I'll just go and Google for a picture and take a picture from somewhere and stick it into your story, if you have not checked the copyright situation, you potentially could end up with a very large bill for using that material. So you need to start really thinking about copyright. It includes everything you do. So be aware. Now, you might say that you've got away with it in the past and you've just taken pictures off the internet and for your social media accounts. And of course, lots of people do that, but you're now a professional journalist. And as soon as you become a professional journalist and you are publishing in a professional environment, people will start to take notice. It's one of the reasons why journalists are influential, is because people take notice of what they do and what they say. But it means that their lawyers are also taking notice of what you do and what you say. So if you steal someone's pictures, and that's what it is, if you just take someone's property, their picture, and just use it without permission or without checking the copyright situation, you have potentially broken the law. So what's the key legislation? Always the starting point, as I say. So it's the Copyright Designs and Patents Act 1988. So that's one to remember, the Copyright Designs and Patents Act 1988. So what is it? So it basically protects people's skills, creativity and labour. So if you put in skill, creativity or labour into producing something, then the law protects your right to control and to own that. Copyright exists as soon as the work is created, and some people get a bit mixed up with patents and copyright. It's not like a patent where you have to apply for it. As soon as you create something, so as soon as I take a photograph, the copyright exists. I don't have to apply anywhere for that. It doesn't have to be registered. So what is protected? So here's the kind of basic definition of what's protected by copyright. So it protects you from any unauthorized copying of all or any substantial part of an original work. So it's worth us breaking that down a little bit. So it's not just if you take the entire photograph or the entire piece of work that breaches the copyright. If you take a substantial part of it, so if the photograph, there's a really interesting little piece in it, if you see the shark jumping onto the boat, but it's only down in a small one corner of the photograph, just because it's only a small part of the photograph, you could argue that that's a substantial part of the photograph, because it's the most interesting part. So it's not just about the quantity that you take, it's about the quality. Have you taken the substantial element of that work? And it needs to be original. So have you used some element of skill, labour and judgment to create it? You might argue a phone directory is not an original work, it's just a list, but a poem or a novel or work like that is an original work. So it's taken skill, labour and judgment to produce that. So it protects unauthorised copying of any all or any substantial part of an original work. So things that are not protected, so work that lacks originality. So you can't protect commonplace phrases. So if someone says it's raining cats and dogs, I've just made that up and therefore it's my copyright. That's a commonplace phrase and cannot be protected by copyright. You can't protect facts. So Battle of Hastings in 1066, you can't say that's a copyrighted fact because facts are not subject to copyright. You can't copyright ideas, general principles like communism or capitalism or something of that sort. That's a general idea. It's not an original work taking labour and skill. Information can't be copyrighted. So as I said, the phone directory can't be copyrighted. And importantly, news cannot be copyrighted. So if you happen to be the first person to break a story, you cannot copyright that news. You can copyright the skill that's gone into actually writing it and maybe photographs associated with it and some of the forms of words that go with it, if those are original pieces of work. But the actual news, the fact that an event has taken place or something has happened, you cannot copyright that, which is why news channels, newspapers, websites are all chasing each other's stories all the time. So let's just have a look at a couple of examples. Now, it would help normally if we were in a lecture theatre, I would play you some of these things and show you some of these things. So feel free to go through these slides and play some of the links. It might make it a bit more fun, but it doesn't really work if I try and do it on the video here. So feel free to click on the links. So here's one. So I'm not sure how many people watching this would recognize this person or this character, but I'm pretty sure you will recognize that character. So on the left is Willy the Wizard, and he was invented in 1987, and it's a story all about a schoolboy wizard who goes to a college for wizards where he learns his arts and has lots of adventures. And Harry Potter, of course, you'll be well aware, is the story of a schoolboy wizard who goes to a college to learn his arts and has all sorts of adventures. Now, that led to a big legal case where the author, the family of the author of Willie the Wizard, tried to sue or take legal action, against J.K. Rowling, the author of Harry Potter, to say that Harry Potter had broken the copyright, had breached the copyright of Willie the Wizard by taking the original idea and presenting it as her own. It went on to a very long, quite bitter legal action. The author of Willie the Wizard actually died before it was completed, and in the end, the family ran out of money trying to sue J.K. Rowling, and it was never shown that she had breached the copyright. Just to be completely clear, I'm not suggesting that she did breach copyright, but it certainly led to a long and bitter legal battle over that allegation. Jay-Z, I think it was Goldie Looking Chain. I don't know if you ever come across a Welsh group called Goldie Looking Chain, and they produced a spoof video about on the basis of New York State of Mind, and they did a spoof on YouTube called Newport State of Mind, and it's quite a laugh. If you click on the link that's on Blackboard, you can have a listen to it. It's quite a funny spoof, and in the end, EMI, the publisher of New York State of Mind, got a court order and forced them to take down the spoof because they said it was so similar to the Alicia Keys Jay-Z version that it breached the copyright because it was too similar, even though it was clearly presented as a spoof. You'll be aware of Robin Thicke and Pharrell Williams with Blurred Lines, a song which is sort of controversial for a number of reasons, but one of the reasons that it's controversial is that the family of Marvin Gaye claimed that that song was based on a Marvin Gaye song, Got to Give It Up, and they won their case, and they got, I think, $5 million paid to them on the basis that the Blurred Lines was so similar to Got to Give It Up. If you click on that link in the slides in Blackboard, you'll be able to compare for yourself and decide whether the two things really are very similar, but the court decided that they were. And you'll be aware, I'm sure, that Ed Sheeran has also been taken to court by the family of Marvin Gaye over similarities with some of his songs as well. So it's an ongoing process, that of people suing to say that the copyright of one song has been breached by another song which is very similar to it. Much more recent is Meghan Markle. You'll have followed the story about Meghan Markle suing the Mail on Sunday for breach of privacy over the publication of a letter she wrote to her father, and she won that case. The court decided that her privacy had been breached. Now, at the same time, they were also asked to consider whether the Mail on Sunday had breached copyright by publishing the contents of that letter, and the court decided that they had. They said that the contents of a letter is an original work, taking skill and judgment and creativity, and that it attracts copyright. So by publishing the contents of that letter, the Mail on Sunday had breached the copyright of that particular letter. And you can see there on the right, that's the story the BBC published about the Mail on Sunday being ordered to publish a correction or a statement on their front page. That's since been challenged, but the point is still there, that even publishing a letter from somebody can be a breach of copyright. Interestingly, one of the legal arguments about that letter is the fact that it would appear Meghan Markle's PR consultant had co-authored that letter to her own father. So while she's arguing that it was a private matter and a private letter to her father, she actually has a PR consultant writing it with her. And the reason I'm raising this is that now the courts are having to consider how much of the copyright Meghan Markle owns and how much does the PR consultant own of that letter, which throws up a whole host of questions about what the original intention of that letter was, but that's one for another day perhaps. So that's your basic definitions and some case studies. As I say, there's some material on Blackboard to have a look at those if you want to listen to those songs and kind of judge for yourself the similarities. It's quite fun to do. I'll now end this video and then move on to the next one, so I'll see you in the next video.